Hello, I'm John Fuller. We're continuing our discussion of the U.S. criminal court system, specifically our book, American Criminal Courts, Legal Process, and Social Context. Today we want to talk about an interesting development in the courts, and that is something we call fuzzy justice, or alternative to the courts. Some disputes are settled outside of the criminal court system that traditionally might have been settled inside of the criminal justice system. And this is important because it has an impact upon the quality of justice. Today I want to talk about two of these types of fuzzy justice enterprises. The first is restorative justice, and the second one, in contrast, is military commissions. Restorative justice is a principle that attempts to restore the relationships between the disputants. Oftentimes, in fact, most of the time, people who get in disputes know each other. They have ongoing relationships. They are family members, they are neighbors, they are co-workers, and the idea is if the dispute can be resolved in a way suitable and acceptable by both parties, then that relationship can be restored and sometimes even made stronger by the type of restorative process that they go through. Restorative process usually involves a mediation. In a mediation, these people sit down with a neutral third-party person who facilitates a conversation between them. The victim gets to tell his or her side of the story and how the case has impacted upon them. The defendant gets to tell why he or she committed the offense and express remorse for the poor behavior that they exhibited. These people can come to a conclusion and develop a plan for the future that not only prevents this case from reoccurring, but oftentimes makes their relationship stronger and benefits them in other parts of their life. Restorative justice is a principle that has been tried in some form or fashion in Australia, in New Zealand, in China, in America on Indian reservations, as well as now in the criminal courts. These restorative justice processes hold tremendous promise for disposing of a vast number of cases in ways that makes everybody happy. In many ways, it's what we call a win-win situation. By contrast, military commissions have legal scholars especially concerned. Military commissions have been used many times throughout the history of the United States, but today they are being used in the war on terror. And they're being used especially in the Guantanamo Bay prison in Cuba, where people who have been suspected of terrorism have been placed. This has been a particular problem for the United States in that these enemy combatants, as they are termed, are not really prisoners of war and are not afforded the protections of the Geneva Convention. They're not American citizens, so they don't get the protection of the U.S. Constitution. In many ways, they have no protections whatsoever. The military commissions, therefore, are designed to find them guilty of crimes and determine punishments for them, but they do so without providing these defendants any type of legal due process protections. By this we mean they have been held in detention for long periods of time, in some cases for many years, without even being charged with a crime. They have not been given access to attorneys for many years. Now, as these military commissions are getting underway and attorneys are afforded to them, the attorneys do not always get all the information that the prosecutor has, as we do in the discovery process of the criminal court system. The rationale behind this is national security, that the government says that it cannot provide all the information they have because there are other concerns in terms of terrorism that must be taken into account, and we just have to trust that the military commission has the evidence that they say they have, and processes the case in a fair and impartial manner. This is of real concern to legal scholars because it's an adversarial process where one of the adversaries has its hands tied behind his back by the military commission rules, and people are really concerned that these people who may be terrorists may not be terrorists and are being railroaded by the military commission process. It's going to be interesting in the next couple of years to see how many of these cases are resolved by military commissions, what kind of sentences these people receive, especially given that some of them have been in prison 10 years before they even get a trial. So this fuzzy justice concept, both in restorative justice processes where people agree to the disposition of the case, and in contrast, the military commission process where the military judges hand down sentences without due process is going to be a very interesting item to watch in the future. Thank you.